Welcome everyone who has RSVP'd and joined this call, especially the Mozilla community members who've been very active and involved in this campaign, and the friends of the internet in general. My name is Rachita Taneja, and I've been campaigning on privacy and data protection in India with the Mozilla Foundation for over a year now. I'm also a co-founder of the Save the Internet campaign on net neutrality and the Internet Freedom Foundation. As you may know, the Justice Sri Krishna Committee submitted a draft of a privacy and data protection bill to the Ministry of Electronics and IT, which was then released to the public. We're hoping that this AMA can be of service to the attendees to better understand the bill or to answer any questions you may have. Mozilla has for long been a strong proponent of privacy. The fourth principle in the Mozilla Manifesto says that individual security and privacy on the internet are fundamental and must not be treated as optional. So to that effect, we've been working with the community, with the government, with the media, with experts and other stakeholders so that India's first privacy law is robust and protects users. Before I introduce you to the panelists, I'd like to take you through the process points very quickly. We're recording this call and it'll be posted on our website, privacyfirst.in. I'll be moderating the session today, which basically means I'll be your voice on the call. So if you want to ask a panelist a question, you just put it into the Etherpad document. And I'll pick it up and pose it to the panelist. If you would like to ask a specific panelist a specific question, you can also leave their name with it, and I'll ask that panelist the question. Which brings me to the panel. Our first panelist is Amba, a lawyer and a policy advisor based in New Delhi. She leads Mozilla's policy work in India, and prior to Mozilla, she was working as a government consultant and as a researcher on internet policy issues. Welcome, Amba.
Hi, everyone.
And joining us from San Francisco is Jochai Ben-Avie, who is Mozilla's Senior Global Policy Manager, and he leads our global policy work. He's worked on data protection and other internet policy issues around the world. Hi, Jochai. Thanks for joining us in the morning.
Happy to be here.
Great. So, Amba, would you like to start us off with an introduction to this moment, why it's important, and basically how we got here?
Yeah. So thanks, Rachita. I think I'll start with the fact that privacy threats are no longer hypothetical. I think we all know that whether it's Aadhaar or whether it was the massive scandal post Cambridge Analytica, even in India, these episodes are just reminders that there are both government and corporate threats to privacy. And the unfortunate truth is that as of today, we lack any effective protections for individuals. So although we have a patchwork of certain laws for the IT sector, they are unenforceable at best and really inadequate. So we're in a situation where the threats are growing, but there are no legal protections. And we've been, and those of us that have been advocating for privacy have been saying this for a while. But how come suddenly the government got to work? I think if I had to peg it to one thing, it would definitely be the cases against Aadhaar. So as we know, there are multiple legal challenges against Aadhaar, including on issues of privacy. And out of these cases, the government came to court and they told the Supreme Court, look, we're going to pass a data privacy law. In fact, they said that they would pass it by Diwali last year. So obviously that didn't happen. But instead, they did quite quickly set up a committee. That committee was headed by Justice Sri Krishna, a former judge of the Supreme Court. And this committee was tasked with actually drafting India's sort of first comprehensive privacy law. So I think it was now November, almost 6 months ago, that the committee came out with its kind of draft report where they indicated what this law would have and they gave their views on privacy. And they also gave all of us a chance to chime in and advocate for what we thought this law should include. So several stakeholders, including Mozilla, participated in this process. And then 2 weeks ago, they came out with this. I'm just going to show you. The point is to show you that it's a very hefty document. That's just the bill. So they came out with their final report, which is a 200+ page document explaining their views, their kind of final views on privacy. And finally, they also came out with an actual draft bill. Now, the fact that they've come out with this draft law is also significant because it means that there's already a ready bill that could potentially move to Parliament as soon as the winter session, which is later this year. So I think this moment, I can't stress that enough, that this moment is so critical for all of us to kind of engage, give our inputs. The government is going to soon be seeking inputs officially to chime in to make a bill which we think is a strong start and actually a great bill that can protect Indians.
Thanks so much, Amba. That was really useful. Jochai, it would be great if you want to add anything to that, but I actually wanted to ask you about this moment in a global context. And this is a question that has been asked on the Etherpad as well. One of the participants has asked us, how does this bill compare to other protection laws like the GDPR?
Sure, great question. I think we're seeing a wave of data protection laws around the world. We have certainly GDPR is probably the most well-known and reflects an update to data protection laws that have existed in Europe for about 20 years now. One of the reasons that you saw that flurry of emails from many of the services that you used back in May is because that was when the GDPR, the European Union's General Data Protection Regulation, went into effect. And now, it's easier for companies to maintain one sort of set of privacy protections in their technical systems and how they work with their users and their users' private data than it is to sort of maintain different regimes across the world. And so we're certainly seeing other, companies that are affected in particular by the GDPR. We're also seeing other countries that are either adopting new laws for the first time. So, for example, Brazil recently passed a data protection bill. Kenya is currently considering a data protection bill. And then we're seeing other countries that are trying to get what's called adequacy. When the EU determines that your country has a sufficiently high level of data protection, let's say on level with the GDPR, then you would be able to freely move data between the EU and data on European citizens to that to that other jurisdiction. So, for example, there are a number of countries that already have adequacy under the previous data protection directive, and now they're looking to the GDPR to update their laws to get adequacy again. And so I think that this provides a real opportunity. We saw Japan recently got adequacy, and a lot of countries are looking at that. I think there's a real opportunity for India to get adequacy, potentially. The bill that was put out by the Justice Sri Krishna Committee is very much inspired by the GDPR in many respects. Some principles like collection limitation, purpose limitation, data storage limits. These are principles we can dig into as this conversation goes on. The law applies pretty broadly in terms of protecting Indians' data, no matter where the entity processing or collecting, storing, using, analyzing that data exists. I think there are areas where the Sri Krishna Committee draft is better. So the GDPR has a exemption for processing, grounds for processing, I should say, for legitimate interest, for example. And so that sort of says that companies, under certain limitations, can process your data when it's in their legitimate interest. The Sri Krishna Committee bill takes the approach of calling this reasonable purposes, and it's much more narrowly defined. And so I think that's positive, that's welcome. And then just to wrap up these comments, I think there are definitely more concerning elements in the Sri Krishna Committee bill as well, including around requiring everyone's personal data, private information that directly or indirectly identifies you, must be stored on servers in India. So I hope that we'll have a chance to dive into that a little bit more, Rachita, but maybe I'll pause there.
Yeah, thank you. Amba, would you like to add something to that? We already have a lot of questions that will talk about what you were saying, Jochai. So
yeah, let's charge ahead with the next question, I think.
Great. So, the first question is basically like, what does data protection mean? Who is being protected from what? And does it apply to companies and the government?
Okay. So a lot of questions there. I think the first thing, and this is not a phrase I made up, but I think it's a very powerful one, is that data protection is about protecting people and not data. And sometimes in these conversations about data protection, we lose that. I also noticed that someone's asked on the Etherpad that, what is personal data? And I think that answers this question, because a data protection framework is about protecting data that pertains to you and that can be identified to you. So it's not just a piece of information that, somebody out there, has this characteristic, but it's in a way that it can be traced back to you. And because it can be traced back to you, it's uniquely positioned to actually cause you harm. So whether it's, a loan that you didn't get because of some personal data that relates to you, or whether it's some very sensitive health information, which you would rather not have being shared with all kinds of parties, or, with the Cambridge Analytica example, data that could actually impact democracy, elections. So there are very many manifestations, but at the end, it's about protecting data that pertains to individuals and protecting individuals. And maybe just one more thing I'll add is that we often use the term privacy and data protection kind of interchangeably, but there is an important difference, which is that data protection is only a part of privacy. Privacy is a much bigger and kind of all-encompassing concept, which really goes to the heart of your freedom to decide to make decisions that pertain to your own life, whether that's your sexual orientation, whether that's the work that you do, whether that's your right to have an abortion. So you'll see that many of the cases that come before the Supreme Court that are on privacy deal with these issues. Whereas the conversation we're having here today is specifically about protecting informational privacy or privacy related to your data.
Rachita, can I just add one more
Yes,
point
please.
there? So you'll hear us throughout this conversation and other conversations you'll see in the media and in your communities, the term data processing. And so I just wanted to quickly sort of define that as well. Data processing means a lot of different things, from collecting private information to storing it, to organizing it, to altering it, to just retrieving it if you put it in a database and take it out again, to use, to combination, to indexing, to disclosure, and otherwise sort of making information available. And that's only some of the things that are listed in the very comprehensive definition of data processing. So know that if Amba and I say data processing during this conversation, we're talking about a very wide range of activities that when we're talking about what companies and government entities do with the private information about you that you've entrusted to them.
Yeah, thank you. You actually answered another question that we have from the participants about what does the term data processing mean, and does it include collecting data as well? Great, thank you. So in terms of, you mentioned that companies and Cambridge Analytica, you mentioned companies, you touched upon that, but we have a question which says whether the government can be held accountable to breaches and leaks as well under this law. And
yes.
Yeah,
I think that was in the previous question as well. So yes, this data protection law, and indeed any comprehensive data protection law, should apply to government and private sector alike. Of course, like in theory, that's true. There are certain exceptions, including in this law, to government processing of data, and maybe later in the conversation, we can get into what are these exceptions that are made for the government. But what's important to note is that the government, is possibly the largest data collector in the country. That's one. The second is that often when the government asks for your data, you don't always have a choice. So there is no meaningful choice, especially if you're kind of dependent on the state for services. So I would say that data protection frameworks, not just equally, but are possibly even more important for the state. And so again, one of the, I think, the welcome, something we should kind of celebrate in this bill is that the obligations in Chapter 2, which we'll get into, all those obligations generally apply both to government entities and to private entities.
And a quick follow-up to that, which was a question about security agencies and checking on surveillance. There was another question about whether they would also fall under this. What would the bill mean for them and for them processing data?
Sure. So there's two things here. One, that there is a chapter in this act which is called partial exceptions, and which means that basically there are certain kinds of processing data will not be subject to all the rules that are generally applicable. And so you'll see that although it doesn't mention the agencies themselves, it says that if you are processing data in the interest of the security of the state, then you really don't have to follow many of the provisions of this bill. Now, on the face of it, this is a problem, and actually this is not a new problem. India has very little regulation of surveillance by the state in the country. But one of the protections that this bill does kind of introduce is that it says that at the very least, the including if it's for the security of the state, needs to be backed by a law that's actually passed by Parliament. Now, what does that mean? It means that currently today, many of the intelligence agencies, many of you may not have even heard of them, but they probably know a lot about you. They actually operate really, in some senses, outside the law. Like, there is no law that kind of sanctions what they do, that regulates what they do. And so what's powerful, at least, I mean, I don't think it's nearly enough, but at least what this bill does is that it says that, look, any surveillance needs to be backed by a law passed by Parliament. And it also says that any processing, including by these agencies I just talked about, needs to be both necessary and proportionate. Not necessary and proportionate, needs to be both fair and reasonable. These are all legal terms, so fair and reasonable. Should put it in quotes. Jochai, would you like to add to that?
I think it's just important to recognize how much of a sea change that is in terms of regulation of surveillance and state entities. Again, I think we'd definitely like to see more language around that. And I think that sort of authorized by law provision is going to require a sort of further debate within India on, what should the appropriate limits on government surveillance be. And I think that for those of us who are engaging with the government and putting pressure on the government, it's important to make sure that that conversation ultimately happens.
Yeah, so there's a follow-up question to this saying, what is considered to be reasonable purpose according to the panel's, the Sri Krishna Committee's proposal?
Sure, I think Jochai kind of touched upon this earlier, but I think maybe just to back up, I want to just explain where this kind of fits into a data protection framework. Like, why does the law have to get into what purposes are reasonable and what aren't? It's actually because, in general, companies and the government, though in this bill less the government, but at least companies generally have to ask for consent. And not just any consent, they have to ask for meaningful consent. Now, like in the GDPR, there are certain if there are certain situations where it's recognized that maybe consent is not it's not appropriate in that particular situation. Although consent is very important, there might be situations where it kind of doesn't, it won't hold its purpose. So for example, if there's a real inequality of bargaining power between me and the person asking for my consent, then consent might be meaningless. And so you have to have a kind of other ground to look at that situation. Or say if I'm trying to fraud in my organization, then perhaps it doesn't make sense to tell the person or tell the organizations that I'm kind of investigating them. So that's another situation where perhaps consent won't be appropriate. So what this provision does is that it says, apart from consent, there are a limited number of reasonable purposes for which companies might kind of process data based on that without asking the user for consent. And why we said that in some ways this is kind of better than the GDPR is because in the European law it says legitimate purposes, and it really doesn't define what that is, or honestly put very many limits on what you can claim is legitimate. So imagine a situation where a company says, I want to collect all your data. I'm not even going to ask you for your consent, but I am going to process people's data in furtherance of the goal of innovation. Now, innovation is great, but we're not sure what they mean by innovation, and that is definitely not a clear or specifically defined aim. And we've said this in our submission, we don't think in and of itself innovation should kind of justify any kind of use of your data without any questions asked. So that's a situation which I think this bill has managed to avoid by saying that even within reasonable purposes, there's a number of conditions that have to be fulfilled. They've actually even given a list of kind of illustrations. I'm going to try and pull that out while we continue. But yeah, a list of illustrations where they actually say these are cases which would count as reasonable purposes. So I know they mentioned, for example, whistleblowing or network security, areas where they've already identified that this strikes a kind of appropriate balance and can be claimed as a reasonable purpose. And it indicates that something as broad as innovation is unlikely to count.
Yeah, I think just one other point on that is that in addition to sort of specifically listing out what counts as reasonable purposes, while giving some flexibility to the regulator to expand that list in the future, it also says that, they have to consider the public interest in that purpose, the rights of, the individual in that processing, what reasonable expectations they might have, the individual might have. And so there's actually quite a few protections here.
Great. And, just going off of that, who is going to make sure that, this is another question, who is going to make sure that our data and privacy is protected? Who's going to be responsible for it?
Yeah, so this is really critical because you can have all the protections in the world, but if you don't have an effective regulator that can enforce them for you, once again, individuals will be left powerless when faced with large companies or the government. So to answer your question, this bill does create a regulator. They call it the Data Protection Authority of India. So this regulator will have kind of three, I'm sort of simplifying it, but they'll have three broad functions. The first will be they'll kind of monitor and audit to make sure that all of these list of obligations in the law are actually being fulfilled. So that's kind of an audit or a monitoring function. The second is that if if, for example, I have a complaint and I think that my data has been misused or my rights have been violated under the Act, then I can complain to an authority. And this authority is called the Adjudicating Officer. Now, this Adjudicating Officer is empowered to not only fine the company or, in fact, the state and say that, you have violated the law and therefore you have to pay this penalty, but they can also actually give me as an individual compensation if I have suffered loss because of that violation. So that's quite powerful. I think now the GDPR is moving towards having more of that complaints mechanism, but I would say that this is quite revolutionary even globally to have a system where you can complain directly to an authority. But remember, it's not all about complaints because many of us don't, even when we do suffer, it might not be worth our while to go through the administrative process of actually filing a complaint. So there's a lot that the regulator itself and the adjudicating officer itself can do. So it can take up an issue, it can do an audit and find that a company has been violating its obligations under the law and therefore haul them up, do an investigation and actually mete out pretty hefty fines. So there is an authority under this act. My one caveat, and in case we don't hit this later, is one of the major issues and big concerns with this bill is that it doesn't seem like this adjudicating officer that has all this power is going to be very independent from the government. And the reason is that this law really doesn't specify who will select. All it says is that the central government will decide who this adjudication wing of the regulator, and they will kind of get to decide everything related to this wing, who will be on it, how will that person be selected or those people be selected, etc. So we think this is a concern, and we're going to really argue that the bill should say more about how this wing of the regulator is actually selected and put in place safeguards so that there's some arm's length distance between the government and the body that will hopefully regulate the government.
Jochai, would you like to add to that?
Yeah, let me just hop on. So agree with everything Amba said. I think a couple points is that while we have some concerns about the sort of appointments and procedures for who this adjudicating officer will be and some of the appeals, the regulator is still set up as independent from the government. Will have power over the government. So there's a lot of potential here for the government, for this regulator, the Data Protection Authority of India, to hold the state accountable if we can fix some of these, procedures around, how these individuals are appointed. And I think that's quite powerful for a regulator to be, independent, well-resourced, able to hold the state accountable like that. Apologies for these pings going on. And one other sort of meta point is about the regulator can sort of issue additional guidance and regulation. Amba sort of touched on this briefly, but we're going to sort of pull that out. Data protection law is hard. It's big, it's complex, especially when there isn't a sort of a foundation in law already, as is the case in India. And you're really articulating a lot of these rules and norms and values for the first time. It's helpful to have a regulator that's empowered to give additional guidance, right? And so we don't, getting some of the really great principles that exist in the Sri Krishna Committee's bill is really important, because that what allows the regulator to further develop and articulate what some of these rules and regulations should look like into the future. And that could be helpful for also stopping things that no one could consider today would be an issue.
Yeah, so there's a follow-up question on the point about the Data Protection Authority from our participants. So isn't the Data Protection Authority too powerful? It has vast search seizure powers. There's a single body for the whole country. How will they be accountable to us?
So that's a great question. I think that's always a tension when you're creating a regulatory body that's meant to regulate not just the private sector, but the government and be the custodian of individuals. Obviously, regulators are not infallible. They're made up of human beings, and human beings are imperfect. But with that said, I think this should not be a reason to prevent us or to make us kind of cynical about having a strong regulator in the first place. I think a lot of the signaling value of having an empowered and strong regulator is to tell large companies, global companies that operate in India, the government, that there is the potential of an actual penalty. If in place, the alternative was that we had a regulator with very little powers, this whole act on all of these rules and protections would be rendered meaningless. And to go to your point, of course, there is a fear that this regulator might misuse its powers, but that is why you put checks and balances to make sure not only a degree of independence from the government, but also things like the tenure of the people that are working there so that they are not kind of perverse incentives. And various other ways in which you can really empower and kind of make an independent regulator. So I agree. I think we need to think really hard about how we can do this, but I would really be reluctant to say, we don't want to create a monster, so let's do nothing. Because I think powers are what gives the regulator that kind of signal value to all these stakeholders and tells them that if they mess up, there will actually be consequences.
And structurally, there are also some checks on the regulator. There are reports that they have to put out every year. You can appeal decisions to an appellate tribunal or to the Supreme Court. So you maintain some also substantive rights of against the regulator if you feel that their powers are being abused.
Great. Moving on to the next set of questions. I don't want to spend too much time on the Data Protection Authority. Moving on to the next set. There's been unrest about data localization. So could you take us through what it is, what the problem with it is? Because there are questions about global companies collecting massive amounts of data. Does it need to be stored locally, and what regulatory checks the government plans to put to ensure there's fair play?
Yeah, so great questions, and certainly big point of contention in this bill. I would start off with saying that storing data locally doesn't necessarily make it more secure. There's nothing inherent about most jurisdictions, certainly the Indian jurisdiction, that makes it safer for your data than other jurisdictions. And the fact that the bill only requires a copy of the data to be stored in India seems to suggest that protecting your information is not really the goal here. Indeed, this can very easily be used to facilitate easier surveillance. If the information has to be in India, makes it a lot easier for law enforcement, for intelligence services to get access to your information. From a business perspective, you want data to be able to be stored, wherever it makes the most sense in the world, because, from a company perspective, we want to get your information to you as quickly as possible. It's a little counterintuitive, but sometimes the fastest way to get, information from Delhi to Bangalore is to go through London. And one of the sort of key principles of the function of the internet is to deliver data as expeditiously as possible through sort of a best efforts principle. And so when you have to store data in one place, that sort of disrupts that efficiency and sort of gives another sort of different organizing principle of where you store the data, and that can increase costs. It can increase the time it takes to deliver internet data to you, and storing it all in one place, a whole copy of the data set, is also a very big security risk, in that it sort of creates this huge honeypot for anyone to treasure trove of private information all in one place. What's increasingly common is for companies to separate out data sets and keep some data here and some data there and some data over there, and not keep it all in one place, just for exactly this reason. And if you're a small company or even a medium-sized company, and you're only going to keep one or two sets of data, and one of them is required by law to be in India, that's going to be a sort of overriding principle. And so it's, hurting the efficiency of the routing of the internet. Some of those extra costs might get passed on to you as the user, and enable sort of greater surveillance. And I think we'll have to sort of see how that would measure up to some of the necessary and proportionality standards that we've seen both from the Supreme Court and in other parts of this bill.
Just a follow-up to, there's a follow-up question on this. If companies are not allowed to store and process data outside India, would it mean we'll be devoid of potentially good services that would be available elsewhere?
Could you repeat the question, please?
So if companies are not allowed to store and process data in India, data outside India because of this data localization rule, would it mean we'll be devoid of potentially good services otherwise available outside India?
It's possible. I think, the Indian market is such a large and important one for many companies that they probably will comply with whatever the law says in terms of sort of having to locate, data here. It's possible that we've definitely seen some companies that, even though Europe is a very large market, lots of, users and customers there, we definitely have seen companies that, sort of said, we're not going to offer our services in Europe anymore because we don't feel like we can comply with this law. So I think that there's part of that to do the data localization bit, and part of it is just generally strong data protection requirements in general. We'll have to sort of see how that plays out. I don't know if you have anything you want to add to that.
Yeah, maybe one thing which is Jochai's already told you that the government can't really claim that this data localization move is for security. So what reasons do they give? And if you read the report, the kind of main reason that they give for why data should be, a copy of data should be stored in India, is that they say that it'll be much easier to enforce this law because we kind of can hold companies ransom and say, your data is here and so we have access to it, or for law enforcement purposes, they have easier access. And I think while they might give this reason, it's actually something that has a lot of us concerned, because what it means is that, like we said, we have very little regulation of government surveillance in the country. And given that backdrop, that means it's just that much easier to access data of Indian citizens. And currently, given the situation, given that we have such little surveillance regulation, this is more a concern than anything else, that it's going to be a proxy for easier surveillance, not just easier enforcement.
Thank you. So we've just hit half point. If you're just joining us, we've started taking questions from the community. We were just talking about data localization. And you can just ask us your questions by adding it to the document that has been shared on this call. Great, so moving on to something that a lot of people have asked questions around, and Amba, you briefly touched upon it. What does this mean for the Aadhaar? How does this bill impact it? Can we stop using it? Can we opt out? There are a bunch of questions around Aadhaar, but I'll give it to you one at a time.
Yes. So I think for me, Aadhaar is definitely like the giant elephant in the room. Like I said, it's one of the reasons that kind of precipitated this kind of quick process of actually getting a committee together to get a law. But at the same time, it's a very complex issue of how exactly this law is going to impact Aadhaar. I'm going to give you my take on it with the caveat that this is a complex issue and we're going to still be working out what this will mean. And also with the other kind of background, for many of you might already know this, is that the Supreme Court is currently hearing these various legal challenges on Aadhaar. And so some of the major limits to this project will hopefully also come from this judgment. We're awaiting this judgment perhaps even by as soon as the end of the month. So with that background, I think the question we should ask is, how does the Aadhaar project as it stands today, does it match up to the standards that this bill talks about? Obviously, the Aadhaar Authority, the UIDAI, is handling large amounts of data. There's no question about the fact that it would definitely be kind of subject to this law if this law was enforced today. Not just that, because the authority handles not just any data, but biometric data, and not just data for few people, but data of almost more than 1 billion people, there is no question about the fact that it would be classified as what the bill calls significant data fiduciary. So this is like a big jargony term, but what it means is there's a special class of data processors or entities that are considered to have kind of more risky processing, either because of the volumes that they are processing or because, like I said, of the kind of data. So, and these significant data fiduciaries are actually subject to stricter requirements. So the UIDAI, if it were to be subject to this law, and if this law were enforced, would be a significant data fiduciary and then would have to answer to many requirements. So I can give you a flavor of the kind of questions we might ask of the Aadhaar project. So we could ask, does Aadhaar as a project adhere to the principle of collection limitation? Collection limitation in this bill says that you only collect as much data as is necessary to fulfill that purpose. Is biometrics necessary for all of the uses to which it is being put today for these authentication purposes across private or public purposes? Or maybe more specifically, purpose limitation also in this law, where we could ask, is it, when we gave our consent to Aadhaar, could we have predicted that it would be used for X, Y, Z kinds of services? Is this a narrowly defined purpose, or is this a very broad or a too broad purpose? So we can ask these questions from these principles in the law. But at the same time, the law, and this is something that we've kind of already been critical about, the law does say that government entities don't actually need to obtain the meaningful consent of individuals in the when they are doing service delivery. So a lot of the concerns, and this in fact is the exact same argument before the Supreme Court right now, which is that Aadhaar is now mandatory for so much service delivery. This law says, and service delivery by the government includes everything from, IRCTC to GSTN to your PDS to all kinds of services. It's a huge range. So in all of these cases, the government need not take the meaningful consent of the users. They only have to show that such data collection is necessary, or when it's biometric data, that it's strictly necessary. Now, these terms sound promising, but at the end of the day, we're kind of worried that in the absence of consent, what does strictly necessary mean? Will the government just be able to kind of blanketly say that everything is necessary because we're the government? That would be a really unfortunate outcome. And so that's something that we want to push the government and the drafters of this law to make sure that there's clarity on these kind of key terms. So yeah, that's a long-winded answer to say that this bill might make progress, but there are also some kind of major loopholes that we might be worried about.
If I can just jump in to add a couple additional points. I think one of the key things here is the UIDAI will also be, and the Aadhaar system will be subject to audits, which, I think given the repeated sort of breaches and, leaks of data from the Aadhaar demographic database in particular, that I'm sure all of you know better than I do. I think this has been a real sort of clear need for these kinds of security audits. And so that would be required by, this bill, doing data protection impact assessments, really having to think through what the impact on your privacy will be based on sort of new expansions of, the Aadhaar system, for example, would be something that would have to be considered. And so I think there's some strong provisions here. And then ultimately, like all processing under this bill, it would have to be fair and reasonable and respect the privacy of the individual. And so I think that provides a basis to sort of push the UIDAI and the government on certain data, practices with Aadhaar data.
So there was a little mention of biometrics, and there are questions on the document which says, what constitutes personal data. So Amba, if you could just take us through those different, bits of terminology that's mentioned in the law.
I think one easy way to think about it is kind of 4 categories of data. The first is non-personal data. So what you would call purely anonymized data, which, like I said, cannot relate to me as, Amba, but it could just be a fact, and it's impossible to reverse and relate that to me. So that kind of data would be considered out of this act. This act does not deal with those kinds of anonymized data sets. The second category is personal data, which is, like I said, data that can be identifiable to me. And the law defines that in quite a strict fashion. And then the third is sensitive personal data. Now, sensitive personal data is the kind of subset of personal data. The thought behind this, and this is present in, I would say, almost all robust data protection laws around the world. The idea behind that is that there are certain types of data that kind of reveal or have the potential to reveal very sensitive or very intimate details about you, and therefore the risk of harm is kind of elevated. There's a separate debate to say that, all personal data might reveal something sensitive about you, and so it's not necessarily a strict distinction, but at least we know that, say, genetic data, biometric data, sexual orientation status, transgender status, these are data points which are especially sensitive, and if an entity is directly processing that kind of data, they need to be put on red alert. And so that is why this law does make a distinction between personal and sensitive personal data, and puts slightly higher or stricter conditions on sensitive personal data. So like I said, biometrics is part of that. We're quite happy because the first draft of this report actually didn't mention biometrics as sensitive, and we were like, this is definitely one of the most sensitive data, because it really can identify an individual across time. So we're glad to see that that's part of the list. And like I mentioned, there's a fourth category, which is critical personal data. Critical personal data is a subset of sensitive personal data, and it actually isn't really defined in the law at all. All it says is that certain categories of data might be kind of identified by the government as critical, and we can demand that that data never leaves the country. So not just store a copy in India, like Jochai mentioned, but that data can only be processed in this country. It can never kind of leave. So there are these kind of four distinctions, and to your point, biometrics is part of sensitive data.
Great. So is there anything else about the Aadhaar that we should know with regard to this bill? I know you covered like the large portion of it. Is there anything else that we need to know about it?
So I think I'm like bringing it upon myself, but so many people have asked me, can we opt out of Aadhaar? So I'm going to try and answer that question, and I'm not with the caveat that it's a complicated question. Now,
and that is a question, by the way. Someone did ask that.
I didn't just preempt it. Okay, so the Aadhaar authority under this law, like we said, they aren't obligated to obtain your consent. And so in a sense, the law doesn't have something which says your right to opt out or even your right to delete, but it has a provision which is within the definition of consent, which says for consent to be meaningful, you have to be given the ability to withdraw your consent. Now, whether or not the UIDAI is obligated to take our consent, the truth is that they have obtained our consent. We all signed consent forms, whether we read them or not. And so a question could be, in hindsight, and this will depend on, what happens post the Supreme Court judgment, but a question could be that should this consent form also tell us that at any point you can withdraw your consent? And if you can say that I no longer consent to my Aadhaar number being used, then there's another principle in the bill which is called storage limitation, which says once the purpose is fulfilled, delete the data. So that means that I can say, A, I withdraw my consent, and B, storage limitation. Now, if I'm withdrawing consent, there's really no reason for you to be storing my data, so delete my data from your database. But think of the very many hoops that you would have to go through to actually get this together. I think that it would put a kind of a burden on the individual, which is why I think having a more general, meaningful opt-out from the authority itself, rather than something that individuals have to individually claim and fight for, would be a better outcome. And that's something that we have to wait and see what the Supreme Court says on that question.
And I would say that the right to object to processing is a right that exists in the EU GDPR and in other data protection laws. During the sort of consultation process for drafting the Sri Krishna Committee's bill, in that original white paper that Amba referenced with their sort of provisional views of the committee, they did say that the right to object may not be appropriate in the Indian context. We would disagree with that. But it's not reflected, not included in the sort of bill that was put forward by the Sri Krishna Committee to the government of India. But I think that's a point that is well worth fighting for as this process moves forward.
So stepping back a bit, there are questions about, can you just give us a quick analysis of what are the loopholes in the bill? What are the critical things we need to look out for while we go forward? You've already touched upon some of these in the past 45 minutes, but it would be great if you could just have a point-by-point breakdown of, what we should be looking out for.
Okay, so firstly, I'm going to say that I hope all of you at some point, if not today, get a chance to look at the Mozilla policy blog post on our views. It's called Mozilla Weighs In on India's Data Protection Bill. We have a list of what we think is good, what we think is okay, what we think is bad, and maybe even ugly about this bill. And we make it very clear that we're going to be advocating to change these elements that are not right before this bill actually goes to Parliament. So we have been thinking quite deeply about what are these issues that we think need to change to actually make sure that this is a strong bill. So I'll just list them. I think some of them I've already talked about, and if I haven't, just chime in, Rachita and Jochai. So the first is, of course, on data localization. We think that this requirement to store a copy of data in India is nothing more than a potential proxy for surveillance. It does not make our data safer, and it has really kind of negative potential impacts on global and on Indian business. So that's one big one. The second is that when it comes to government use of data, I think creating this very broadly worded exception to consent for all government services seems to be overreach. If you look at so many markets, like I mentioned, where government services play in the same market as private services, we want to ask, why does a private company have to obtain meaningful consent but not the government? We understand there are situations where consent might not be appropriate, but the current wording of the bill is just too broad, because service delivery by the government could capture anything and everything that the government does, and that's a major concern for us. And maybe a follow-on point to that is this definition that the bill is filled with these terms of necessary, strictly necessary. They say that for personal data, you just have to show that the processing was necessary to fulfill the purpose, and for sensitive personal data, that it was strictly necessary. It's not clear immediately what these terms mean, and the distinction will be really, really important as a check on government. And so we think there needs to be more guidance either in the law or kind of coming out with it to explain these distinctions. Jochai, am I missing any other big ones? Right. Also, just one more I remembered is the bill does give individuals certain rights. So your right to ask a company or even the government, both companies and the government, for a copy of the data that they have on you, a summary of the data they have on you, to make changes to your data, to update your data, etc. However, they do mention that a fee might be levied on this. And we're concerned with that because I think just saying that a fee might be levied really is creating a distinction between the haves and have-nots and just replicating these inequalities even when it comes to privacy. So we think there should be stronger language to say, as far as possible, it should not have a fee, so that companies can't just easily rely and say, look, we need to charge you for this service, because we think it's the right, and there shouldn't be this distinction with it. Anything else?
Yeah, I just want to pick up on two things you said earlier, just while we're sort of listing this out. And if you mentioned this, my connection cut out for a minute, so apologies if you covered this. But on processing for the partial exemption for the security of the state, the state is in those cases, which is separate from the this exemption for the service delivery, provision of services or benefits. There, the government is exempted from a lot of protections. So that sort of purpose limitation, collection limitation, some of the security safeguards, that we talked about previously, don't apply when it's processing for the security interests of the state. So that's concerning. And then Amba also mentioned this earlier, but some of the questions and concerns we have around the independence of some parts of the regulator, the Data Protection Authority of India. We want to make sure that those get fixed up as well.
Yeah.
And really quickly, what are some of the things that we need to make sure don't get diluted in when the bill is edited or when there are edits made to the bill? What are some of the key things that we're happy about and should not be diluted?
So I think I read somewhere that when this bill came out, many stakeholders were unhappy. So we heard rumors that the government was unhappy, that industry was unhappy, even civil society was unhappy. And so the reason for this is that this in some ways is a real sea change in the legal regime. We're going from almost no protections to suddenly having pretty strong limits on both companies and the government. I think to me, like the most progressive feature of this bill is the fact that these obligations of collection limitation, purpose limitation, security safeguards, audits, keeping records, all of this applies equally to the government and to private entities. So irrespective of that question of consent, even if they don't have to take consent, and even if they are exempt from consent, which we might have a problem with, even if that's true, they are still subject to all these obligations. And I think that's something which neither the government nor the industry might be too happy about, but it's something that as citizens we should just continue to endorse and remind the government that that's something that is important to citizens, even if it may not be important to the entities it's going to affect.
Great. So there are a few questions about Mozilla and how we plan to work on this, how we plan to react to this, put out comments, etc. So before answering that, Amba, it would be great if you could take us through what you've been working on over the past 2 weeks since the bill has come out, because I know you're taking a lot from the community as well, talking to them, meeting with them, taking language from them, hearing their concerns.
Yes. I don't know if many people from the Delhi meeting are on this call, but we recently had a community meeting, and we actually tried to understand what are these legal terms like collection limitation. And one of the examples that kept coming up was, why does a Torchlight app need access to my location data? That actually came from one of the community members. After this bill was released, we wrote an op-ed in the Times of India a couple of days after it came out. And one of the examples that I used was that Torchlight app, because it kind of stayed with me. And the reason I pick up on this example is just to say that often we are so, particularly as lawyers, we're so in the weeds of the text of the bill, we forget what it would actually mean to have a law on the books. We forget why any of this is important. And so it's really useful to actually work with the community to come out with these examples, to not just convince each other, but actually convince the government why these provisions are important and should be passed and should not be diluted. So I guess one would be just picking up on inputs that we receive. And in terms of what we've been doing, we've just been really working hard to kind of immediately just getting through this bill, getting through this report, and putting out Mozilla's view in the public domain. We say this often, but we think Mozilla is really uniquely situated as a company that makes products and works in the technology space, so knows what is required to build products, but also believes that privacy is fundamental and should not be treated as optional. And I think that because we believe in both these things truly, we have a really important voice in this debate. And whenever folks say that privacy is kind of anti-innovation, we want to be the voice out there to remind them that that's not true and give our own experience to validate that claim. So we plan to be very active, and we plan to, Jochai and I are already working hard on coming out with kind of our opinion on this bill, and hopefully the government will open up for consultation soon.
Jochai, would you like to add to that? Anything you'd like to? So the specific question, oh, sorry, go on.
Yeah, please go ahead.
So the specific question that was asked about Mozilla and how we plan to react. So that's a bit of how we're trying to react to the bill. But in terms of putting out submissions, in terms of putting out comments, in terms of the public consultation, how is Mozilla going to be involved in this?
I think you can continue to expect us to engage at every step of the process. Sometime before Amba joined our awesome team here, several of our community members came to me and said, hey, we really want Mozilla to be, working on this fight, to get involved in fighting for data protection and privacy in India. And, we're here because our community has asked us to be here. And so I think you'll continue to see us engaging with the government, sort of, the more formal things that you do when you're trying to influence the government, like filing submissions that are very, detailed and very sort of policy legal heavy. You'll see us, continue to sort of taking meetings and sort of talking to the government directly. And I think you'll continue to see us doing more advocacy work and working with our community and helping to educate people about what's in this bill, what it means, where it can be improved. and giving sort of opportunities for folks to rally and push for this.
Yeah, and a follow-up to that, and I can't find the question, but I read it somewhere, is how can folks help out? How can people help out? You know, we have community meetings in different parts of the country. We do AMAs and things like that. What specific things can people do to help with this, or to help Mozilla in its mission?
So I think we're still, like I said, getting inputs for the community and finding a way to do that in a more organized fashion is something we really hope to do over the next month. So a part of that is obviously, holding community meetings in different parts of the country, and we plan to do that over the coming months. Another part of that is obviously we're now present on some of these Telegram groups, and so if you have one of the many Telegram groups that the Mozilla community has, do reach out to us. We'd be happy to be a part of that and field any questions. But I think the most important thing is that we've already hopefully put out our views and really put out enough information on privacyfirst.in for hopefully many of you to start having your own conversations in your own communities. So I would say, start speaking to your family, start speaking to your college, university groups, and if you feel like there isn't enough information and privacyfirst.in is kind of is missing something, let us know, and we can help add to those graphics, give you things that you can use in those conversations. But I think we want to just let this kind of fly in a decentralized fashion, and hopefully you can take these conversations forward.
Yeah, and in terms of advocacy, just to answer that question really quickly as a campaigner, we're using privacyfirst.in to basically simplify some of the complex things that are being spoken about in the bill, some of the legal jargon that is being simplified into graphics. We're hopefully making a video soon. So we are working towards putting out more educational content. So when the time comes for us to actually be prepared to take action on an issue, we're ready. I just wanted to add that in real quick. We have 4 minutes left. Any last thoughts, Jochai, Amba?
Okay, last thoughts, I would say, I just want to reiterate that sometimes anything related to the law makes you feel either bored or it's too complicated and you don't want to engage, and I completely understand that. But I think this is a law that will impact business, it will impact individuals, it will impact your relationship with the government and with all these companies that you interact with every day. So I think that it's not enough for a few of us to keep saying the same thing to the government. Tweet at the government, tell the Minister of IT that you care about this bill, that you want this bill to be passed. We're going to be working around thinking about how to campaign around this, and Rachita will be in touch with you soon on these kinds of issues. But basically, we just want to get the message across that the Mozilla community and the policy team really, sort of believes that a data protection law is really long overdue, and we want to have the best possible law we can have.
I think that's a great note to end
on. Mic drop, no, but laptops are expensive, so let's not. Okay, great. Thanks everyone so much for joining us. Thank you, Jochai and Amba, for doing this. We'll be posting a recording online on privacyfirst.in, where you can also find the simplified points. What's good about the bill, what's bad about the, what's the loopholes that we should look out for, etc. So you please feel free to go to privacyfirst.in for more information, and we'll also have the video there shortly. Additionally, you can follow Amba and me on Twitter and stay updated on some of the work that Mozilla is doing around privacy and data protection, plugging our
followers on Twitter.
Yeah, shamelessly plugging for followers. Great. Thank you so much, everyone, and have a great rest of the day.
Thank you.
Bye.